Welcome to INN Student. INN Student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us law student Rutu Patel. She is going to speak on analysis of section 101 BNS murder. She is from KES Shri Jayantilal H. Patel College of Law. So without wasting further time, I would request her to commence with the lecture. Thank you.
Good morning everyone. My name is Rutu Patel and today I will be discussing a very prominent topic, which is the analysis of section 101, that is murder, of the BNS 2023. This is a new code that replaced the Indian Penal Code on 1st July 2024. Section 101 is the heart of India's law on murder, one of the gravest offences known to humankind. Understanding it is crucial for lawyers, law enforcement officers, and every citizen because it deals with the ultimate violation of the right to life. The process of defining culpable homicide as murder can be found in section 101 of BNS. It says that everything that a person does that is likely to cause death or that they plan to kill someone is considered murder. Section 101 of BNS is a part of Chapter 6 of offences affecting the human body in BNS. Unlike culpable homicide, which has a broader definition under Section 100 BNS, Section 101 BNS specifies when a death-causing act constitutes the gravest form of murder. As long as it doesn't fall under specific exceptions like grave and sudden provocation. Though there are still some situations in which culpable homicide is not regarded as murder. Section 101 states in a sense, whoever commits murder shall be punished with death or imprisonment for life, and shall also be liable for fine. This mirrors the old IPC, ensuring continuity while harmonizing language with the new code. The BNS didn't redefine murder itself. It relies on the general definition of culpable homicide in section 99 and 100 and distinguishes murder as the most aggravated form. For conviction, under section 101, the prosecution must prove death of a human being. The causation can be that the accused's act or omission caused that death. Second, the intention or knowledge. The mental element must fit the definition in sections 99 to 100, which is the culpable homicide amounting to murder. Absence of exceptions. If circumstances like private defense under section 34 or sudden provocation apply, the offense may be reduced to culpable homicide not amounting to murder. The key legal principles are as follows. Number 1 would be intention versus knowledge. Court distinguishes between a deliberate intent to kill and mere knowledge that death is likely. Number 2 is mens rea. Without guilty mind, which is example in accidents or in sudden deaths, section 101 does not apply. Number 3 would be doctrine of exceptions. Similar to IPC, exceptions such as grave and sudden provocation can mitigate liability to section 100, which is culpable homicide not amounting to murder. Some of the landmark case references that these ruling guides interpretation of section 101 are as follows. Number 1 would be Virsa Singh versus State of Punjab 1958. It is clarified that the intent and injury is nexus. KM Nanavati versus State of Maharashtra 1962. Classic case on sudden provocation. The most talked about case, which is the Bachchan Singh versus State of Punjab 1980. laid down the rarest of the rare doctrine for the penalty of death still applied today: punishment and sentencing. Death penalty or life imprisonment plus fine. After Bachchan Singh, death is reserved for the rarest of rare cases. Courts weigh aggregating factors, brutally motive and mitigating factors in terms of age, reform prospects, etc. Comparison with the old IPC: while the word is almost identical to Section 302 IPC, the BNS aims for clearer drafting and easier interpretation. Importantly, the BNS as a whole emphasizes victim rights and speedy trials. Contemporary relevance. Rising debates on abolition of death penalty keep Section 101 in the spotlight. Modern issues like honor killings, mob lynching, and dowry deaths are prosecuted under this section when intent is to kill is established. Moving on to our final segment, which is the conclusion. To conclude Section 101, BNS preserves the essence of India's murder law while fitting into a modernized penal framework. It balances society's demand for justice with constitutional safeguards like due process and the rarest of the rare principle. Understanding this section is not just an academic exercise, it is about protecting the fundamental right of life. The definition of responsible homicide as murder is given in Section 101 of the BNS, along with a list of exclusions. The act by which death is caused is done with the knowledge that it is too imminently dangerous that it is, in all probability, cause death, and it is committed without any excuse for incurring the risk. This includes intent to cause death, behavior that is extremely likely to cause death, and circumstances in which culpable homicide is not considered as murder, such as provocation, self-defense, lawful public obligations, and unexpected fights and consent. Thank you.
Rutu, thank you very much. It was a very crisp and a nice explanation of this 101 of BNS, and with a nice comparison to the 302 of IPC. Thank you very much, and a small token from Hammurabi to you.